Hello world, good morning, namaste, and Nisam Bulavinaka from Sydney, Australia. I am Sashi Singh, and welcome once again to the highly anticipated weekly edition of Sashi Singh's Talking Point program on this last Sunday in August. In episode 33 this week, we will shortly meet our chief guest, Mr. Aman Ravindra-Singh, Fiji's human rights lawyer and an advocate for freedom of speech and freedom of expression. Today, in a no-holds-barred, one-on-one interview with Aman Ravindra-Singh, we take an in-depth look at the defamation proceedings that was brought against him and the committal proceedings which were initiated that subsequently led to a sentencing of 10 months immediate imprisonment. We will ask our chief guest as to the reasons as to why and how he departed from Fiji, and what are the serious ramifications that he faces back in Fiji, and his future plans. All that, plus a lot more, with our chief guest Aman Ravindra-Singh coming shortly. I hope wherever you are well settled in to enjoy what promises to be a captivating, engaging, and enlightening interview with my chief guest. Today, as we go around the world by the wonders of Facebook Live and YouTube, I have one special request, one special kerikeri to ask of you. Today's broadcast is surely going to be an eye-opener. I therefore request each one of you to please share this SSTP page on your own timelines so that we may share the interview with Mr. Aman Ravindra-Singh with as many interested people as possible. If you share this live feed on your own timeline, all your friends and relatives will be able to watch this program as well. I believe this is an important program to share because it will show how the wheels of justice really rolls in Fiji. Ultimately, you will be in a position to make your own judgment by the end of this program. To ensure that you receive instant notifications of all future programs, please like the SSTP page and follow us too. So welcome to the Thinking People's program, Sashi Singh's Talking Point, live on Facebook and on YouTube on this last Sunday in August. All right, now that we are all settled in, let us see what were the key happenings of the political week in Fiji and Australia. A big welcome to our regular contributor, Nikhil Singh, who just happens to be on the road today. Nikhil, welcome to episode 33 of SSTP, and thank you very much for still being able to join us this morning. I know you're attending a conference, and a wonderful sacrifice on your part to step out of the conference to be with us for your segment. Welcome, Nikhil.
Thank you, Sashi, and apologies for any background noise or interferences, but I'm trying my best with technology, but let's see, hoping this works.
It certainly is working right now, and before anything goes wrong, let us begin your segment. We'll start with a joint study done on the Fiji National Provident Fund by the International Transport Workers Federation, the ITF, and the Fiji Trades Union Congress, a story that you covered last week. Now, the ITF said government has been using the Fiji National Provident Fund as a private cash cow to underwrite risky loans and pay for pet projects, putting the retirement fund at risk. The Attorney General, Ayar Sayed Qayyum, clearly not impressed, has questioned who is the ITF. Has anyone responded to the Attorney General, Nikhil?
Well, this took me by surprise, Sashi. I thought the Attorney General would have this information on his fingertips as to who the ITF is. The Fiji Trades Union Congress has released a statement. The statement reads, and I quote, "The Attorney General has again displayed his ignorance and arrogance when questioning the credibility of the International Transport Workers Federation, the ITF. The Attorney General, the FTUC says, would do himself a favor if he simply read the report and understood its contents rather than making personal attacks to deflect the real issues at stake. The report is a fair and independent overview of the fund and makes clear recommendations. It must be clearly understood that the FNPF is a workers' superannuation fund and not an extension of the Ministry of Economy or the AG's slush fund, Sashi."
Now, Nikhil, we've been hearing about that open heart surgery at the Lautoka Hospital, that it will begin soon, something the government has been saying for several months now. The National Federation Party claims the government is misleading the people. Who is zooming who in this instance?
But this is certainly hard to follow, Sashi. Every time you pick up a media report, you'll see that surgeries are starting soon. Now, the National Federation Party leader Biman Prasad claims many concerned heart patients have been told they are only being screened and given clinic review dates instead of being booked for any type of surgery at the Lautoka Hospital. He said this in a statement where he also claimed the Fiji First government had been, I quote, fooling and misleading the people of Fiji by promising the start of free open heart surgeries at the Lautoka Hospital from May. Prasad has also claimed that he has extremely reliable information about Aspen Medical's intention to now outsource medical services to at least one other provider, despite initially signing an agreement in January 2019 to manage Lautoka and Bar hospitals. So Aspen is the group that is given the contract to manage the Lautoka and Bar hospital, Sashi. The NFP leader says this raises the question of Aspen Medical's competency and plans to provide state-of-the-art health and medical services, and he has called for an independent inquiry to determine the truth.
All right, now to an issue that has been causing the People's Alliance Party some grief following one of the party's provisional candidates allegedly classifying Indo-Fijians as Vulangis or visitors. The party has been referred to FICAC by the Supervisor of Elections. What action, if any, Nikhil, has been taken by the People's Alliance leader, Sitiveni Rambuka, and has the PAP's partner, the NFP, said anything on the matter as well?
Well, this is one that the People's Alliance has tried very hard to put to rest. People's Alliance leader Sitiveni Rambuka said the matter was discussed at a joint communication legal administration meeting last week. Following this, a general caution has been given to all members of the People's Alliance Party to be sensitive to the views of all ethnic communities, to be conscious of the politically volatile climate we live in, and to be careful about what we say or write. The NFP has described the PAP's provisional candidate's comments as, I quote, unfortunate choice of words. Both Prasad and Ramuka held a joint press conference yesterday, and amongst other matters, this issue was again addressed where the People's Alliance leader said, and I quote, I apologize to those who were offended or insulted by it. Those are not the views of the People's Alliance. Ms. Warid has told us that her comments were well meant. We have told her that she must be more sensitive in her use of words. Sashi Liliana Warid, the provisional candidate, she remains a provisional candidate. She has not been disendorsed.
All right, we seem to have a little static in the connection, but we'll persevere, we'll keep going. Nikhil, is this next Tory a much ado about nothing, or is this the seed for a new beginning? A few of the opposition party leaders met informally last week in a sign of unity. This gathering was initiated by Suva businessman Nirmal Singh Chima, a former guest of SSTP. Have the leaders said anything after this informal get-together?
Well, Sashi, in attendance were former Prime Ministers Mahinda Chaudhry and Sitiveni Rambuka, who are also leaders of the Fiji Labour Party and the People's Alliance, NFP leader Biman Prasad, and the General Secretary of Unity Fiji, Ratu Mosese Bakinideva. Manua Kamikamida, who's also a People's Alliance member, accompanied Mr. Rambuka to this informal gathering. Now, this is what the FLP leader has said about this after the meeting, after the informal gathering, and I quote, "I saw the meeting as an opportunity for party leaders to demonstrate their willingness to cooperate to bring about a change of government. A genuine show of solidarity among them will, in my view, go a long way to motivate our people to be part of the change. Even though we are contesting the elections as individual parties, because pre-election coalitions are not permissible under the current electoral laws, there is no reason why we should not cooperate to achieve a common."
All right. Looks like we thought we'd lost you, but keep going.
According to Fiji Village, the NFP leader Biman Prasad said the People's Alliance, I'll say that again, NFP leader Biman Prasad and People's Alliance leader Siti Rambuka confirmed that they met with the leaders of other parties, including Mahenda Chaudhry, in a social setting, but it has got nothing to do with their partnership, Sashi.
All right, and closer to home, a follow up on your report last week about the former Prime Minister, Scott Morrison, secretly appointing himself to 5 ministerial portfolios. You told us that Prime Minister Anthony Albanese was awaiting legal advice. Any update on that?
Yes, there is a report in the ABC which said that Prime Minister Anthony Albanese has released the much awaited advice on the legality of his predecessor's appointment to the resources portfolio after first sharing it with his cabinet. The Solicitor General has found that the former Prime Minister Scott Morrison was validly appointed to the resources portfolio, but not notifying ministers, Parliament, or the public fundamentally undermine the principles of responsible government. This is not the end of this matter, Sashi. Mr. Albanese has announced his intention. In fact, he's announced that there will be an inquiry into the appointments that Mr. Morrison made.
All right, and Nikhil, the rail workers' ongoing industrial action potentially is going to cease following negotiations between the New South Wales Rail Transport Bus Union and the state government last week, and the parties making some headway. But there is more trouble for the Perrottet government, this time from our nurses. What do you have on that front?
Well, this was reported in Guardian Australia, but it seems that the rail workers' strike is not over as yet. There appears to be more discussions to be had. The New South Wales Nurses and Midwives Association said nurses across the state will walk off their job while maintaining life-preserving measures for 24 hours on the 1st of September. This, according to the union, is in direct response to the government's inaction. The union wants one nurse for every 4 patients to ensure the system is not overstretched and patients receive the best care. The New South Wales Premier Dominic Perrottet says his government has invested more than any other state in building and upgrading hospitals over the past decade. Sashi, a showdown is looming.
Wow. Well, thank you very much indeed, Nikhil, for your contribution. An extra effort on your part to leave the conference and to deliver your segment. I truly appreciate that, as always, very nicely presented. Enjoy your conference, but let me tell you, you are going to miss one hell of a live program. Hope you can watch it later.
I certainly will. This is one not to be missed, Shashi.
All right. Well, all the best. And once again, Nikhil, thank you very much. Lovely to have you on board. Well, let me tell you, our viewers, this is absolutely unprecedented. We'll begin our program proper in just a moment or so, but I've really got to thank our viewers who have tuned in this morning in such large numbers. And I just want to say hello to Buna V, Sanjay Ramesh. I've lost a whole lot of names because my phone went off. There's Bongatini, I think, as well. There's a whole lot of them. Thank you, Vince. So, look, wherever you are tuned in from this morning, this afternoon, or this evening, if you're in the USA, welcome. And you are watching Sashi Singh's Talking Point on Facebook Live. As I say, we ask the questions that Fijians all over the world want answers to. Fijians want to know. Please like and follow the SSTP page if you have not done so. I have an important announcement to share with our viewers. Sashi Singh's talking point, SSTP recognizes that questioning, constructive arguments, and opinions are part of conversation, but posts with aggressive personal attacks, profanity, name-calling, swearing, defamatory in nature and/or threatening will be removed immediately, and offenders will be blocked from being a part of the SSTP program. Let's observe these rules and let's all enjoy the program. Let me also say, before we begin to speak with our chief guest, that some viewers have actually written to me, some have called me, and have asked me to get Aman Ravindra-Singh to state why he left Fiji in the first few minutes of the program. In reply to these people, let me tell you that's not the way I approach things. I shall unpack different compartments to this court drama and approach the matter in a chronological manner as best as I can. Just like a Graham Grisham crime novel, you don't solve the matter right in the beginning in the first chapter. By traversing through many twists and turns, we will get to the end. Let me assure you that the end will be, well, you'll have to wait for it. Ladies and gentlemen, now it's time to meet our chief guest on SSTP. Mr. Aman Ravindra-Singh is a Fiji human rights lawyer and an advocate for freedom of speech and freedom of expression. Before I begin today's Sashi Singh's Talking Point, episode 33, with my chief guest, I have an important announcement in the form of a disclosure. And that disclosure is that my chief guest today, Aman Ravindra-Singh, is related to me. He is my younger brother. So shortly, you will have my brother Aman and myself on the screen. And there is another far more handsome brother who is at his home observing things today. So today I find myself in that unusual position. Having said that, I can assure you that there will be no impediment because I can state that this would be like any other interview. I will ask the questions and my chief guest will attempt to answer them. Now that we've got that out of the way, it is perhaps safe to say that many people in Fiji and those Fijians living around the world were not really aware or perhaps did not pay much attention to the fact that Aman Ravindra-Singh had a defamation proceeding against him, which then turned into a committal proceeding, which then led to a sentencing. However, before he could be handcuffed and taken to prison to serve a custodial sentence, he flew out from Fiji. Today, we will look at the chronology of events right from the defamation proceeding, explore the offending defamatory statements, the judgment handed down in the defamation proceedings, the court orders that were issued, the compliance or non-compliance of those orders, the committal proceedings that took place, and the sentencing that was handed down by the presiding judge. And most importantly, we will ask our chief guest the reasons as to why and how he left Fiji and what are his plans for the future. I hope you are all ready for this, the 33rd episode of Sashi Singh's Talking Point, as I welcome my chief guest, Mr. Aman Ravindra-Singh. Aman, good morning and welcome to SSTP.
Good morning, Shashi, and thank you very much for having me on the program.
All right, first things first, do you have a fan or something running there? There seems to be a whirring noise coming through.
No,
This.
but,
All right, well, all right, we'll try and continue as we are, and hopefully that's better. That noise has suddenly disappeared. All right, well, look, thank you once again. Good morning and welcome once again. All right, Aman, let me ask you firstly, how are you?
I am fine, thank you.
Well, Tuesday before last, that is the 16th of August 2022, the rumor mill went into overdrive in Fiji when you failed to appear in the High Court in Suva for sentencing. Some speculated that you had gone to New Zealand, some suggested that you were in Australia, and you were, in fact, quoted in the Fiji Times as saying, "I could be in Kandavu for all anybody knows." Would you like to confirm your whereabouts?
All I can confirm is that I am safe, I am well, and I could be anywhere. I could be in Kandavu, probably planting, or otherwise elsewhere, or even in Singapore. I have been cited in Auckland, I have been cited in Sydney. I think I have also been cited in Singapore. But look, I think my location is not the issue. My safety and well-being is the issue, and I assure the listeners, the audience, that I am well.
All right. That noise seems to be bugging me. I don't know what happens. I don't know whether you turn on and off the switch or whatever you do. There seems to be a noise when you speak. Hopefully, we can rectify that as we go along. I see that your speaker is, your mic is muted right now, and that noise has disappeared. And let's go on. You'll need to unmute your microphone, please. That's better. As soon as you're unmuted, that noise comes. We'll persevere. Aman, you were sentenced in absentia to 10 months immediate imprisonment. And of course, when you failed to turn up to your sentencing, a bench warrant was issued against you. We will shortly explore the background to your case. However, at this juncture, let me ask you, why did you leave Fiji?
I think there is a lot more to explain to the audience and state what has occurred and what led to my departure from Fiji prior to the sentence, which was delivered on 16th of August. And I think if I'm allowed to start from the beginning of how I got into that predicament, it would obviously explain a whole lot. And also, the viewers will be able to get a proper and full picture of what has occurred and what has happened and what I have faced in the last 3+ years.
All right, well, I respect that. And as I said in my introduction, I will unpack it in a chronological order. So perhaps we'll get to that very, very quickly. Now, there are some people who have said that you absconded. Did you abscond?
No, I did not abscond. Someone who absconds is basically someone who runs away from a sentence. And I did not run away from the sentence. I left Fiji before a sentence. And the sentence was not pronounced until the 16th of August. And I left like any other ordinary Fijian would depart from the country. I bought a ticket from a travel agent. In fact, I bought it from the mall in Lautoka, in open view of people, and paid for my ticket. And then on the right day, I left through the airport in Fiji. I would have absconded if I took a boat or some other means, a submarine.
All right. And how was your experience at the airport, at the counter? Were any questions asked?
My experience at the airport has always been one whereby the moment I present my passport to the immigration officials, I get odd looks, and there is always been typing and typing by the immigration official into their computers, and then there's reading on their part, and it usually takes a little bit more than the normal. And I've noticed that for the last so many years. And on this occasion, it was the same. So I was not in any way concerned or under any sort of pressure. And after a few minutes of writing and reading by the immigration official, my passport was stamped for departure, and I was waved off with the wonderful passing comments of have a wonderful flight, sir.
Yes, that was documented as well. Have a wonderful flight, sir. Have a nice flight, sir. And I certainly hope that the customs officer is safe in his or her workplace, uh, and that customs officer did very well, nice and courteous to bid you goodbye as well. Well, Aman, did you have any issues in the migration zone whilst you were waiting to board the aircraft?
I had no issues. As earlier stated, I went through the normal process like every other person. I stopped waiting for my flight, waiting for the boarding call. I was in the lounge, met a few people whom I have known for some time, enjoyed coffee, and once the call was made, I proceeded to the aeroplane. I, in fact, took photos of the plane and uh, and then took my seat.
All right. Now, were you at any time afraid when you went to the Nandi International Airport, or at any time while you were going through customs or while in the migration zone?
I had nothing to fear because one, I'm not a criminal, or I wasn't running away from anything, and I didn't really have fear, although I had concerns about other matters against me, but not I was not in any sort of fear.
There is a bench warrant in place for your immediate arrest now. What are your thoughts regarding that?
Well, firstly, if someone does not appear in a court of law and a sentence is to be pronounced, the first thing that happens is a bench warrant is issued and the sentence is not pronounced. And until a determination is made about the whereabouts of that individual or individuals, only then the court would once again convene. And once there is a determination made that the person is not within reach, then only would a sentence be passed in absentia and with a pending bench warrant. However, on the afternoon of 16th, I noted there was a certain odd manner in which my pronouncement was made. But before that, on the morning of 16th, FBC had put that Aman Ravindra-Singh would be sentenced today. And once I read that, I knew that my sentencing would take place on that same day. And the time given was 2:30 p.m. It was almost like I was being led to the death gallows for an execution. The entire nation was informed about the sentence. And when I did not appear, instead of just simply uh, issuing the bench warrant, my sentence was still pronounced. And it was on the back of that the bench warrant was then issued against me. But it should not have been the case. It should have been a bench warrant would have been issued for my location or whereabouts to be determined, and then only my sentence was to be pronounced. So I found that rather odd on that day. But with regards to the bench warrant, that's the procedure. That is the process of the courts. And if someone is not there on the day, on the hour, a bench warrant can be issued. That's at the discretion of the judge, and that is what happened on 16th August 2022.
All right. I will now take our viewers to the beginning of the proceedings. And while I do that, may I please request that you mute yourself so that we can get past that noise. And then when you are ready to respond, turn that mic on again. I'm trying to sort of figure out where that noise is coming from. Well, let me now take you to the beginning of the proceedings brought against you. The Prime Minister, Vorenke Bainimarama, and the Attorney General, Ayaz Sayed Qayyum, initiated a writ of summons and the statement of claim on 18th October 2018. They sought the following relief: A. Damages for libel and slander. B. Punitive, exemplary, and aggravated damages. C. An order that the defendant, within 7 days, render in writing a public retraction and apology in prominent print to the plaintiffs, to be published in a daily newspaper circulating in Fiji. D. An order that the defendant immediately remove the subject article from his Facebook page and be restrained from publishing or printing such similar article in any form of social media. E. Prejudgment and post-judgment interest on any award of damages. F. Costs of this action on a substantial indemnity basis inclusive of VAT and such other further relief as this court may deem fit. These were the specific orders sought by the plaintiffs. There were specific orders sought, 7 specific orders sought in all. I must at this stage draw the viewer's attention to Order D, and that I just read, whereby the plaintiff sought an order that the defendant, and I quote, immediately remove the subject article from his Facebook page and be restrained from publishing or printing such similar article in any form of social media. End of quote. I guess at this stage, it is important to share with the viewers the text of the article as identified by the plaintiffs as posted on Facebook by Aman Ravindra-Singh sometime in 2018. And I must state that this material is directly from the judgment handed down on 24th July 2020 by Judge Leonie Senivaratne in the civil jurisdiction of the High Court of Fiji. This is a public document and can be obtained from the court or via PACLI. Let me now quote from the judgment about the article for the sake of clarity. And I quote, "Regime dirty politics. I am sickened at the recent series of temples around Fiji. I cannot help but wonder how, in an election year, in the past 3 months, at least 6 temples have been desecrated. Someone surely wants all the attention. These criminals were well organized, and I am even ashamed that they went out of their way to buy red paint, which was later used when they committed these crimes. Even during the worst days of racial, religious, and ethnic tension since 1987 and 2000, we never had 6 temples desecrated within a period of 3 months. These series of desecrations appear to be part of a grand plan and not some random act of stupidity and misled thoughts as we have seen in the past. Notice how corrupt Qayyum and Commissioner of Police conveniently appear at temple open forums and promise safety and security. These promises are further propped up by the regime's #1 print propaganda machine, the Fiji Sun, which runs headlines, "We will keep you safe. We won't tolerate these acts." The plan all along has been to, Phase 1, desecrate these temples. Phase 2, create a climate of fear with the community. Phase 3, show up and promise security. Stop this desecration of temples in Fiji for cheap political gains. These sick and despicable crimes organized by corrupt Qayyum, violent Vorenke, and their henchmen. End of quote. And the material I have just read is taken from the judgment of the court. As I said, the judgment was handed down on 24th July 2020 and sealed at Suva on 30th day of July 2020, and the following 5 orders were made, not forgetting that the plaintiffs asked for 7 orders in their initiating application. On the 24th of July 2020, the orders issued by the court were 1. The defendant, that is Aman Ravindra-Singh, is ordered to pay the plaintiffs $120,000 as damages, $60,000 each to the plaintiff Marimarama and Kayum within 30 days from the date of the judgment. 2. The defendant is ordered to render in writing a public retraction and apology to the plaintiffs in prominent print, which has to be published on his Facebook page and in all local daily newspapers. 3. The defendant is ordered to remove the subject article from his Facebook page immediately. 4. The plaintiffs are entitled to 6% interest on the sum awarded from 7th March 2018 to the date of judgment. And 5. The defendant is also ordered to pay the plaintiffs $8,000 as costs of this action within 30 days from the date of the judgment. Now, Aman, does that sound like a fair description of the article and the orders of the court?
Yes, that is a fair description of how the action started, what the plaintiffs were after, and what the orders were from the court on the 24th of July 2020.
All right, Aman, I'm going to ask you to do something. While I keep our viewers entertained for the next minute or two, can I get you to log out and then perhaps log back in again? We'll remove you from the screen. You'll need to log back in again. And hopefully, when you do that, we won't have that interruption. So we'll get you out for a moment, and you'll need to come back onto the screen, please. Thank you. Yes, folks, don't worry. There's a lot to discuss. And while Aman log backs in again, let me say hello to a few people. Bonavi, Nimbulavinaka, Henry Manulevu is watching, Arun Ban, Vinod Chandra, and also John Wedlock. Thank you very much. Prem Eagle, Bhavin Kapadia, I think he's in New Zealand if I'm not mistaken. Surendra Prasad, Maritham Bole, Nimbulavinaka. Shivani Sharma is also watching. And to all our viewers, if he's back, let's just get him on the screen. Kanchan Charan is watching. Robert Das, thank you very much as well. Sunitha Mishra. Keep those comments coming. Keep those likes coming. Eggy O'Connor has joined us from Brisbane. Bulavinaka Eggy. And Narish Kumar from Newcastle. He's also on the program. There's a lot of people watching this morning. And it is unprecedented that so early in the program, we've got all our viewers really tuned in. And let me tell you that we've just dealt with the initial proceedings that were initiated in court. We've just dealt with the orders that were issued by the court on 24th of July 2020. As soon as we get Aman back on screen, we will talk, and there's a lot of matters to dissect, a lot of matters to bring forward. Towards the end, overnight, I have received a legal opinion from an eminent jurist, and I'll share some of the analysis provided to me in terms of this judgment. So please stay tuned. Don't go away. Let me just go off mic for a moment. Yes, so let me just talk to you and go through some of the comments. Someone said, too courageous, stay strong. Robert Das says, take care, you are our hero, and Fijians are behind you. There is a number of comments coming through. So we'll just begin in a moment, and as long as we know he's there, can we get the person in the background away, please? Thank you. And let me see if I can just add this to the screen. Aman, you are back. Thank you very much. Can you hear me?
Yes, I can. I hope I am clear.
That's much better. That noise has gone. Wonderful. Thank you so much. Well, as I said just before I took you off screen, I read the initiating application. The 7 orders were sought. I then read the 5 orders that were handed down by the court. Insofar as the delivery that I presented, was that a fair description of the article and the orders of the court?
Yes, there was a fair description of what the plaintiffs had sought when the legal action
Oh Lord! All right, seems that you are having internet problems.
was instituted.
You're having I don't know whether it's Wi-Fi problems or internet connectivity. You're frozen. Your voice is cutting out. Um, let's just wait for a moment or so. Um, all right. Yeah, it seems to be working again. All right, Aman, I'm just going to continue. Let us now discuss your compliance with court orders. Can you hear me? You've just frozen again on the screen. Can you hear me?
Yes, I can hear you.
All right. So let us now discuss your compliance with the court orders. What did you do to comply with the orders that were handed down by the court on the 24th of July 2020?
I was in the Suba High Court on the 24th of July 2020. The judgment was delivered. I received a copy.
Oh boy. I apologize for this, viewers. It's
the orders,
sorry, Aman. You just were cut off after you
and I
said I
then
received
returned
the orders.
home to Lautoka.
Hold on.
Obviously, the journey took.
Aman, you are having internet problems. Your speech is being cut off. We lost you when you said I was handed the court orders, I believe. Continue from there.
I received the court orders, and I immediately returned to Lautoka, where I live. And as soon as I got to Lautoka, which was a few hours later, I immediately took out the subject article from my Facebook post. And as one would look at the order, and it states very clearly that order number 3, the defendant was to remove the subject article immediately from his Facebook. And the subject article was removed by myself on the 24th of July 2020. And that was the first compliance by myself with the High Court orders from the 24th of July 2020.
All right. So you complied with Order 3 that said, as you just said, the defendant is ordered to remove the subject article from his Facebook page immediately. Some may ask, why did you have to travel to Lautoka to do that? Why couldn't you do that immediately in Suva using your phone?
I do not have Facebook on my phone, and that is for security reasons. I only can access Facebook from a particular laptop. And that was the reason I had to travel to Lautoka and thereby comply with the High Court order, which had stated immediately remove. And I did just that. There was nothing else that I stopped by to do but to comply with the High Court order. And that was order number 3, to remove the subject article from my Facebook. And I did that on the
Immediately.
24th.
Immediately.
Yes, immediately.
All right. Now, is there any other order that you complied with?
Yes, I further complied with order number 2, which was to issue or render a apology on Facebook, and also render 2 apologies in 2 local daily print media papers. And I, on the 16th of August 2020, rendered a Facebook apology to the first and second defendants, Warenge and Kayum. On the 16th of August 2020, I publicly apologized on my Facebook page. And
All
I
right,
must
let me
point
see
the
if
irony. I
sorry,
must
keep
point
going.
the irony. The 16th was when I issued the apology, and the 16th they sentenced me in Suba. August.
All right, let me just put this on the screen. Hopefully, we can get that on screen. So this is the apology you put on your Facebook page. I hope you can see this. Can you see this? I've just put that on the
Yes,
screen.
I can see that.
So, thank you. So this is 16th August 2020. It says High Court Civil Action number HAC 59 of 2018. And it says Jose Mbani Marama, first plaintiff, Ayaz Sayed Kayum, second plaintiff, Aman Ravindra-Singh, defendant. And the message reads, as per Order 2 of the High Court orders, the defendant retracts the statement, which was the subject of civil action number HAC 59 of 2018, and apologizes to the first and second plaintiffs. So that was your Facebook apology that you posted, and I believe in accordance with the orders, that was part of Order 3. Order 3 was to remove that, and this was part of Order 2, which you published on your Facebook page. Is that correct?
Yes, that is correct.
All right. Now, as per the evidence, you did not comply with the other 3 orders. Why was that?
Order
Well, all right.
5
You'll
do
no.
with
Well, you'll need to
uh,
start again. Sorry, Aman. You'll need to start again because you are having internet connectivity
order
issues.
number order number 1 was for me to pay $120,000 to the plaintiffs, 60,000 each, and I did not have that money, and therefore I was not able to make the payment, and that was order 1. Order number 3, order number 4 and 5 had to do with
This is very frustrating indeed. I don't.
at the end. Ron.
Aman, just we'll just get you off the screen again. Someone's talking in the background about fixing something. Hopefully, we can fix this up once and for all. Otherwise, we might just have to do this again in a little while. Hopefully, that humming noise is gone. Now we've got internet freezing up on you. Get it out, and then hopefully you can log back in again, please, quickly. Look, I did say at the beginning of the program that Sashi Singh's talking point will not entertain any sort of profanity, and if that happens, then the person using these foul languages will be taken off. And I've just noticed on the screen somebody using vulgarity, and if I can ask our admin to immediately terminate that person and, in fact, get that person off the screen. We don't need the likes of that person. We can entertain logic, we can entertain a good, decent debate, but one thing I will not tolerate on my platform is somebody who has vulgarity as part and parcel of their presentation. Can that person on the screen please get off and get Aman back on? We are pressed for time as well. As long as you can fix it up, give us a thumbs up so we know it's all good. So, oh Lord, we'll keep persevering, ladies and gentlemen. There's a lot to unpack, and hopefully things get better. He seems to be back. Please, let's get him on. Thank you. All right. Hopefully this time we won't have any more interruptions. Hopefully the internet connection is good. We were talking about why you did not comply with the other orders. Please explain.
Order number 1 was for a payment of $120,000. Now, I did not have that money, and because I did not have that money, I could not comply. And that's where it was. Order number 4 and 5 had to do with interest on the $120,000 and payment of legal costs, which would have been looked at only when I would have been able to pay $120,000 and the matter was concluded. Furthermore, there was COVID, there was a lot of delays in the court process, and there was also the matter of timing, because I had not even worked for 6 months in 2021. I had not worked for 4 to 5 months in 2020 due to COVID. So there was all sorts of issues which was bordering around that ruling. But what I can very confidently state again is that the one order which had said immediately remove the subject article, I had complied with. And that was the court saying, you must do it right now, immediately.
Okay. Let me now turn to the next chapter of the legal dramas you faced in Fiji. As we have just discussed, the defamation proceedings came to an end with the High Court of Fiji issuing the 5 orders on 24th July 2020. The plaintiffs brought committal proceedings against you by way of an ex parte notice of motion filed on 9th September 2020. This was just 47 days after the initial orders were handed down. Under the second plaintiff, Ayaz Sayed Qayyum's grounds for committal, there were just 2 grounds sought, and this was, and I quote, for failure to obey a court order sealed on 28 July 2020 and served on 1st August 2020, whereby the respondent was ordered to publish an immediate apology and also pay a sum of $120,000 as damages within 30 days from 28 July 2020. First, what was your reaction when committal proceedings were filed against you?
I was utterly shocked because here I had complied with the first order, which had stated that I immediately remove the subject article from my Facebook post. And secondly, on the 16th of August 2020, I had offered the first apology on my Facebook post, on my Facebook page, and therefore I was already in the process of having complied or completed by complying with order 3 and 2, and I was then proceeding to comply with other matters, which was to put the apologies in the newspaper. Because if you look at the order, it also states that order 2 states that there must be an apology on my Facebook page and 2 apologies in the daily print media. So when I received the committal proceedings notification, I was in utter shock. But let me explain one fact. With the committal proceedings, you must, as the High Court rules state very clearly, you must serve the documents in person to the person you are committing or you're making the allegation has not complied with an order or orders. And in my case, I was never personally served. I only got to hear about the committal proceedings against me from the media. And I personally appeared in court on the next date in November. The proceedings had started, documents were filed in September. The first date for the committal, which I found out later from the documents, was the 12th of October, 2020. I was never, ever served any documents for the committal proceedings. And that's the first flaw in the committal proceedings against me and the first miscarriage of justice that I identified. And this again was further reinforced by the plaintiff's lawyers against me by a clerk that saying that I was evading service of the documents, and that is again nonsense, because in October of 2020 I was in Vanwalevu. I had one magistrate's court trial in Lambasa, and another 2 weeks later I had another trial in Sabu Sabu court. But the judgments are out, it's public documents, and that's where I was. So just on someone saying that I was evading is again very disappointing. And on that, the judge then used his discretion to waive personal service and to proceed in the matter. And as I stated, I was able to find out through the media. Certainly, I was not living under some rock, and pick out what was going on. And on the next date, I presented myself personally to the High Court.
All right. Just as a side issue, I remember there were problems in serving certain court documents to someone at level 9, I believe, of a particular building in Suva some years ago, but that's a side comment. Now, Aman, I've had a thorough look at the original orders made on 24th July 2020, and I've read these out to our viewers today. And just a moment ago, I read the plaintiff's 2 grounds for the committal proceedings. It seems that the wordings on the committal proceedings in relation to the failure to obey a court order does not match the original orders. Any comments on that?
In fact, earlier on when you had read what was being sought in the High Court, and then what was ordered on the 24th of July 2022, and what then appeared in the statement for the committal proceedings, I'd just like to take you back to the plaintiff's document which you had read. Now, in that particular document, the plaintiffs had sought orders from the courts with regards to my not being able to publish a similar article. Yes. Now,
indeed.
that was not part of the original court order on 24th July. And when you look at the 24th, the order of 24th July, there are 5 orders only. Whereas what they had sought was 7 orders altogether. So that's 2 orders out. But here is a very clear show of how the court had been lied to by Kayum and his lawyers, and also how they had misled the High Court in Fiji. Now, when you look at the order of July 24, 2020, and I just repeat it, the order only uses the word immediate, and to the listeners, to the audience, just remember this, the word immediate. And the word immediate only appears under order 3. The defendant is ordered to remove the subject article from his Facebook page immediately. And the subject article is the article which you had read also in the beginning, regime dirty politics. So the order wanted me to perform one specific act, and that act was to go to my Facebook page and immediately remove the subject article. And that article is quite a lengthy article.
And I
It's
read
not-
that.
Yes, and the order does not say to remove a word or words or a paragraph or paragraphs. It states very clearly subject article, and that subject article was the one for which the plaintiffs had instituted court action. Further to that, the word immediately. Now, in all 5 orders of the High Court, which was the order dated 24th July 2020, sealed on the 30th of July 2020, there is only one moment when the word immediate is used, and that is order 3. Now, when committal proceedings, for the audience, just to explain some certain court procedure, when committal proceedings is taken out against anyone for non-compliance of a court order, there is a ex parte motion which institutes the proceedings. There's an affidavit to support what is being complained against, and there is a statement, and that is this document here, if it can be seen. That's a statement.
Yes, we can see the statement written on that. Yes, keep
And
going.
in the statement, the allegation of non-compliance is specifically outlined. So let's say, for example, if the court had ordered me to return 15 oranges to my neighbor, that was the order. That's specific. Return 15 oranges to your neighbor, Mr. X. And if I had returned 15 oranges instead of apples, or if I had not returned 15 oranges, but I'd in fact given pears, then I'm not in compliance with a court order. And therefore, the statement would say that I have failed to return 15 oranges. So this particular statement said, and I quote, for failure to obey a court order sealed on 28th, well, that even the date is wrong. It was sealed on 30th. I have that before me. I think, 30th. So even that is already wrong. Served on the respondent, that's myself, was ordered to publish an immediate apology. Now, order 2 does not have the word immediate. Order 2 says the defendant is ordered to render in writing a public retraction and apologize to the plaintiffs in prominent print, which is to be published on his Facebook page and in all daily newspapers. Now, unless Kayum and his lawyers are reading something written in invisible ink, I can't see the word immediate. So what they have done, as I've stated, second case of a major flaw and second case of misleading and lying to the court, is they have imported the word immediate and placed it in the statement for committal against me. That's what they've done. And this is a very, very serious action by Kayum and his lawyers. So now the statement reads, immediate. And therefore, they misled and lied to the court on the statement. And the court has run with this statement despite my bringing it up.
All
So
right. Now, did you at any time raise this in court?
my moment to raise this, and one needs to understand when you are facing something so serious, allegations such as this, is about your approach to how and when strategically in a trial you will be able to clear your name. And I was gearing for the committal hearing with regards to how I was going to put the evidence before the court. And that was what I had been waiting for.
All right. We will discuss the trials very, very shortly. I don't want you to go there yet. Now, let me discuss with you about the recovery of money in a civil proceedings. In that defamation proceeding, Order 1 ordered you to pay the sum of $120,000, and you've explained that you didn't have the money. Can a proceeding where an order, a civil proceeding where an order has been issued to pay money, and if that's not paid, can that be enforced by criminal proceedings?
Absolutely not. You cannot institute committal proceedings to enforce payment of money. While you could do that if maintenance was not paid, but not in a proceedings, defamation proceedings like mine, the one I faced. And I had also brought that up before the court, but the court had ruled against my objection.
All right, let me share this with the viewers. You've just heard Aman say that the recovery of money from a person cannot be enforced by committal proceedings. However, let me say that in the committal proceedings judgment, the presiding judge, Jude Nanayakra, said at paragraph 41, and I quote, "A disobedience of court orders is a civil contempt, but it can become a criminal contempt after it has been proved beyond reasonable doubt for the purposes of punishment if the contempt involves deliberate defiance or is contumacious in nature." End of quote. Now, for the benefit of our viewers, let me say that the word contumacious means stubbornly disobedient or being rebellious. Aman, were you being stubbornly disobedient or rebellious?
Not at all. Where is the evidence that I was being stubbornly or being rebellious? I have never ever disrespected the court of law. Uh, Look, let me put some facts forward. I have been a practitioner, barrister, and solicitor for the last 20 years. I'm a solicitor of the Supreme Court of England and Wales, High Court of New Zealand, High Court of Fiji, and I've been around for a while. I have never ever been held in contempt by any court. In fact, all I have is glowing references from High Court judges, former Chief Justices, Queen's Counsels. So that's who I am, and that's how I have operated. And that is all about my integrity. And for a judgment to find such, I am flabbergasted. As a matter of fact, the plaintiff's lawyers kept on saying those things, which was highly unethical. They kept on putting whatever it was that I had not complied with, and they kept on singing the same tune despite my compliance. And what they should have done ethically was to take a step back and inform the court that they had done or they were wrong and withdraw the action.
All
That's
right.
what
Yep.
competent counsels would do.
Well, yes, because I mean, as a practitioner myself, as a solicitor myself, we are known as officers of the court, and we have a duty, an ethical duty, a moral duty at all times to assist the court. And we have to impart knowledge to the bench, to the judge, if there's certain information and material that we have, and that is a duty that we're obliged at all times to do. Agree with that?
Yes, I do. And that is what I've been doing all along. I've never been pulled up for showing any disrespect to the bench at any level. I've never been pulled up nor investigated for any form of disrespect or rebellion within a courtroom or to the bench.
Let me just repeat that one bit of quote again from Judge Nanayakra. And he said, "A disobedience of court orders is civil contempt, but it can become a criminal contempt." Now, you've just told us that you did no such thing as being disobedient. You were not contumacious. In other words, you weren't disobedient stubbornly. You weren't rebellious. What what do you feel when you read that portion of the judgment? How does it make you feel?
It it feels like that is a description of someone else. I find it even hard to connect with that particular description. That is not me, and that will never be me.
All right, appreciate that. Now, I note that the committal hearing was conducted on 13 June 2022. Had you complied with any more orders, the court orders of 24th July 2020, by the end of the committal hearing? Let me, for instance, take you through the orders. Order 1 was for you to pay the $120,000. Did you pay that, and when did you pay that?
By the time we had reached the 13th of June 2022, this year, I was already facing another action, which was a bankruptcy proceedings brought by the plaintiffs in the Magistrates Court, Lotoka.
Mhm.
So, as we have it, I was now facing double action. And even I found that difficult because you can't duplicate the same action. You're coming after me for contempt of court for not paying that amount, and then you're going after me in the magistrate's court with a bankruptcy action. So by 13th of June, I was facing bankruptcy in the magistrate's court in Lotoka. I was facing contempt. And on the 13th of June, one side fact, 13th of June was set as a hearing date for the contempt. The date before that was on which the hearing was set. I had also filed a summons in the High Court whereby I was challenging Kayum's lawyers on the basis of conflict of interest. Because what I found very odd was that a firm of private lawyers were appearing for the government, and at the same time they were appearing on personal matters for Bainimarama and Kayum. So that, in my view, is a conflict because it then opens up other doors, opens up doors to abuse and lack of transparency and accountability and possible corruption. So that was why I had brought it up before the judge. And my summons was set for hearing on 13th June 2022, this year. So I went to the High Court prepared to argue my hearing, my application, which was on the basis of conflict of interest.
Let me just stop you there for a moment. With all due respect, I will discuss that with you, but I am at that point where I am trying to establish by the time the committal hearing commenced on 13 June. What orders had you complied with those orders that were handed down on the 24th of July 2020, sealed by the court on the 30th of July 2020? So let's just go through that first, please. Order one was for you to pay the $120,000. When did you pay that?
I paid that on the 26th of July, 2022, this year.
All right. Let
And
me put something on screen, if
sure.
you can see that. Now, that is the official office of the official receiver. It's got the date 26th of July 2022, received from Aman Ravindra-Singh of Lautoka, $120,000. And does that look like the receipt that was issued to you?
Yes, that was the receipt I had. I was issued. I received from the office of the official receiver at the Lautoka office.
All right. So, order one, you had complied with order one.
That is
And
correct.
I note something else, though. Whilst you had paid that money, in the committal proceedings judgment, the judge said that the applicants, that's Kayum and Bai, initiated a bankruptcy proceeding against you, and it was this that spurred you to pay the $120,000. What is your response to that?
Well, it's interesting that the judge would make such a comment, but at the same time, the reality needs to be determined. Was I ever placed before a court of law and questioned as to my ability or my lack of ability to pay the $120,000? In these sorts of proceedings, that would have been what should have occurred. With regards to the hearing on the 13th of June, I'll explain that in a little more detail afterwards. I was not given a fair trial either way, so I was not able to participate in the trial. But coming back, I would also have lost my practicing license, my legal license, if I had been bankrupted. So here I was facing committal proceedings in the High Court, and at the same time, I was now facing bankruptcy proceedings in the Magistrates Court. And as I'd mentioned earlier, I was never in a position to make that payment. But now, facing bankruptcy and the loss of my license, and which would also mean the shutting of my office and losing my livelihood, I had to make some very hard decisions. I had to liquidate assets. I had to put my investment properties on the market. I had to sell a property on Chanmari Street in Lautoka. I had to do things in desperation to raise the money. I had to take loans. I'm, if anything, further in debt, and that was $120,000, which I had to then put together through the generosity of people, and then make that payment on the 26th of July, 2022. That was how I was able to comply. It was not being spurred on. It was about survival, and that's what happened, and that is how I managed to make that payment.
All right. Now, Aman, with regards to order two, where you were ordered to render in writing a public retraction and apology on your Facebook page and in all local daily newspapers. You told us earlier that you did render an apology on your Facebook page, and we had that on the screen a little while ago. Now, when did you comply with the newspaper public retraction order and apology?
I was able to print the same apology that I had put on my Facebook page uh, in the Fiji Times and the Fiji Sun, as per the court's order to put in prominent print in local dailies. And these are the two prominent newspapers which I was able to put my apology advertisement into. But if I take a step back, in fact, even with the advertising, I faced issues. When I put my apology and paid for it with the Fiji Times, they asked for the court order, and I had to tell them that here's the court order, send the link, send the court order, and explain that this order is for me to print publicly. And then finally, after a few days of toing and froing, that apology went through. And I had timed both my apologies for a Thursday, but because of the questions asked, my apology was slightly delayed. But the Fiji Sun took a different twist. They were quicker. They accepted my money. I paid for it, and they took the apology. A few days later, Fiji Sun emailed me and said that they had to correct one or two words with Kayum's name. They had to spell it right. And I said, well, I've spelled it exactly like how it's spelled on the court document, on the judgment of 24th July 2020. So I said, look, I have no issues. Go ahead. And they did that. And I had asked that it be printed on a Thursday. Now, by the time they did the name correction and everything, Thursday had come and gone. We had hit another week. And I was told that my apology would arrive on the Thursday. So I was busy, but on the Friday, I checked the Thursday paper and I could not find the apology. Then I checked the Friday paper, and pretty much I checked everything, even the sports column, for my apology. It was not there. I contacted Sun, and there was no response. It's all on email. Finally, on the Monday, I got a response that because the Thursday paper was full, they had moved it to Saturday. And therefore, my apology had gone out on the Saturday, which I found very strange. But knowing how twisted Fiji Sun is, they had only done that to get the wider publication out there because that's their biggest publication. But I had to face these sorts of issues, even with rendering apologies. But yes, I had got the apologies out in the two daily print media.
Now, at paragraph 60 of the judgment, it is stated that the apology and retraction was unacceptable, as it did not refer to the date of the judgment. It did not specify what the respondent was apologizing for. It did not make reference to the proceedings commenced by the applicants. Consequently, it carries very little weight. That's what the judge said. How do you respond to that?
It's again very shocking that I am made to literally jump through hoops of fire, and newer obstacles are created for me, and new definitions are put, newer interpretations are taken, and basically, regardless of what I do, and that is the trend in the entire proceedings, that I'm still falling short, that I am not able to comply, that I did not comply, that I have been rebellious, that I have shown disregard and disrespect to the court. Well, let me put forward a fact. Let me put forward a fact. The court's description of what it does as a fact finder is to apply the law, not anything else. Everything else is out. That's a court of law. It's not a court of emotions. It's not a court of anything else. It's a court of law. So strictly applying the law, the judge should have looked Not that I'm telling him what to do, but obviously that's what the judge would have done. And that would have been to look at the original order of 24th July 2020 and the sealed order of 30th July 2020. And look at the order with regards to the apology. And if one looks at order 2, does it say how the apology is to be framed?
Definitely
No.
doesn't. It doesn't.
No. Does it say which words are to be used and how it is to be used? No. Does it say what size should your font be? Does it say what font to use? Does it say include the case number or not include the case number? No. There are no specifics. There are no guidelines as to how that apology should appear on my Facebook or print media. There are no guidelines. On occasions, a judge would order guidelines and it would say, these are the words which must be in your order. Is it in under order 2? No. On occasions, the judge will say, write your apology, send it to the plaintiff's lawyers, let them agree, and only then, or write your apology, send a draft to the court, send a draft to the opposing lawyers, let us all look, let us agree, and then you may proceed. Is it there? No. When you look at all 5 orders, there is nothing which says how I should frame my apology. So I find it really, really, I find it as a dangerous precedent that once again, the court, after having ruled in its judgment, is able to once again add more terms or to interpret my actions in another form. So I find it as a very dangerous precedent. But coming to what I have endured, I find those comments unfair, and I strongly put forth that the judge got it wrong in law and the judge got it wrong on facts. The orders do not specifically state anything apart from my rendering apologies. And in fact, my apology, which I rendered on Facebook and in the Sun and in the Times, is more than appropriate. If you look at the apology,
At this juncture, let's put the apology on the screen. Let's put that on the screen. And so there you have it, folks. Let me just read that. It says High Court Civil Action number HAC 59 of 2018, Josiah Mbani Marama, first plaintiff, Ayaz Sayed Qayyum, second plaintiff, v. Aman Ravindra-Singh, defendant. As per Order 2 of the High Court orders, the defendant retracts the statement which was the subject of civil action number HAC 59 of 2018 and apologizes to both the plaintiffs. Aman, that's the notice you put. And as I read from the written judgment, where the presiding judge had stated that the apology and retraction was unacceptable as it did not refer to the date of the judgment, it did not specify what you were apologizing for, it did not make reference to the proceedings commenced by the applicants. Consequently, it carries very little weight. Therefore, in keeping with the orders of the court handed down on the 24th of July 2022, do you say that that notice sufficed? I know you've just spoken about things that were not mentioned in the order, but as we've seen, that notice had the HCA number, the proceedings number, and everything else. What's your views?
well, I have gone beyond my call of duty. I could have just simply been arrogant to the point and said, just in the following lines, Aman Ravindra-Singh hereby apologizes to Warrange Bainimarama and Ayas Kayum. I could have just said that. That would still fit within the order and how the order had outlined what I should do. But I did not do that. I had gone out of my way and complied fully because I had continued to respect the orders of the court. And there, I did not do anything otherwise. If you look at the apology, it's got the court number, it's got the plaintiff's names fully, it's got the action number, it's got the high court, the location of the high court, it's got the order I refer to, order 2. It's got a full apology there, and a retraction and an apology. What more was I to do? So I find it very strange and disturbing that that particular paragraph appears in the judgment. But obviously, that was the submission put forward by the lawyers, those who have misled the court on multiple occasions for my contempt proceedings. And that is again their words in their submissions. I remember reading that, to say that that apology was not enough. Right? How stupid can one be? And it's not my problem that these so-called lawyers can't read, but I find it absolutely stupid. And these lawyers were not worth their salt, because it was unethical, completely unethical, to go ahead and openly say in court that that apology was not enough, that that apology was insufficient, that apology was inadequate. As I said, I needed to jump through hoops of fire to comply, and this was a court order which kept changing. How do you keep up? That is very, very sad.
All right. At paragraph 61 of the committal hearing judgment, the judge said, and I quote, "The orders of the judgment pertaining to a defamatory article that was written by the respondent was published on his Facebook post. As was pointed out, is it not fair that the respondent referred to this in his apology and retraction?" Now, how do you respond to this question posed by the presiding judge in his judgment?
Well, isn't it unfair that the defendant, poor me, has to play catch up with new words imported into orders, with new interpretations given into the orders, added to the orders? Isn't that not unfair against me? I, as an officer of the court and as a practicing lawyer, understand court orders. There's no two-way doubts about that. And as per the orders of 24th July 2020, I complied and I acted. But for findings to be made through submissions of their lawyers, the plaintiff's lawyers, that I had not done enough, that I was still not doing enough, that my apology was half-hearted, wasn't complete, I am lost. I am seriously lost, and it's very confusing. But as I said, the orders were in plain and simple English, and unfortunately, certain people couldn't read English or understand it properly.
I must add, that in all my years of practicing as a lawyer, a judicial officer cannot import their own particular quirks into a judgment to substantiate their finding. I find that order as well. Now, Aman, let us look at the reference that was made in order number 3. Let me remind our viewers that in orders of 24th July 2020, Order 3 stated plainly and simply, the defendant is ordered to remove the subject article from his Facebook page immediately. Well, you've told us at great length how you traveled from Suva to Lautoka on the same very day that the High Court handed down these orders, and you immediately removed the subject article. So you complied with that order, correct?
Yes, I did.
Now, here is something that was written in the sentencing judgment passed on 16th August 2022 at paragraph 64. And at paragraph 64 of the judgment, it stated, and I quote, "In respect of Order 3, the respondent was required to publish the apology and retractions to the applicants on his Facebook page. To date, this has not been done." Stop, think, listen. Let's rewind our discussion that we've been having so far. Did I not put on the screen the apology that you put on the Facebook page? And let me see if I can quickly do that apology on the Facebook page. This is, Aman, correct? This is the apology on the Facebook page.
That is correct.
16th August 2020 is the date on the top.
Correct.
Thank you. So this judgment that was passed on 16th August 2022 says that to date this has not been done. Now, I make two observations with regards to the presiding judge's assertion at this particular paragraph 64. Firstly, I note that this was not the exact words of the order issued on the 24th of July, 2020. In fact, Order 3 that was issued on the 24th of July 2020 stated the defendant is ordered to remove the subject article from the Facebook page immediately. The key word here, of course, is immediately, which is something that you followed. However, the judgment stated the respondent was required to publish the apology and retraction to the applicants on his Facebook page, which was, I repeat, not the original order. I think we've earlier discussed this Order 3. Moving on, the second and most obvious observation that I can make is that the written judgment stated in black and white that you had not complied with Order 3, as it has been stated there to date. This has not been done, and the date was 16th August 2022. What are your thoughts in relation to this second observation on my part?
Once again, as I had mentioned, that the judge got the law and the facts wrong. We even till the last day, which was the 16th of August 2022. Just some case history for the audience. The judgment of 24th July 2020 was delivered by a previous judge who had been in carriage of my matter. And this year, that judge had been transferred to Lotoka jurisdiction. So the matter, I think, from May onwards was handled by another judge. So that was what was going on. But I just say it so that if you're hearing two judge names, you understand why they're separate names when it comes to 24th July and 16th August 2022. Again, I think I need to just clarify one point. The hearing for the committal was on the 13th of June, and as I had earlier mentioned, I had gone to court prepared to argue my summons for conflict of interest. And while the hearing date had been set on an earlier date, I was not present in court on that day, and I had appeared at 10:30. By then, my case had been called and a date set, but I had not been consulted with that hearing date. Anyways, I came to court on the 13th of June 22 to argue my summons. That was dealt with, and while I had asked the judge to allow me further time to file written submissions, my application on the conflict of interest was dismissed. And thereafter, the judge proceeded to the hearing of the contempt of court matter, the committal. So at that point, after the plaintiffs had read their submissions, I informed the judge that I was not in a position to proceed to hearing simply because I needed time to prepare. I needed time to brief a legal counsel and thereafter be in a position to then come to court for my hearing. So I made an application to the court to ask for a bit more time to prepare and instruct legal counsel and then return. And I understand the court system, having practiced in the Fijian jurisdiction for many, many years. However, the judge refused to give me any time and dismissed my application. So I again asked that I be given time. So the judge did agree to time, but he said you only have 1 day. And in my position and the circumstances that I had been facing, that was impossible. You can't, firstly, find a lawyer, instruct, and under 24 hours return to court for a hearing was impossible. That was not going to be possible at all. So I again asked for further time, but that was it. But it was a suggestion by the judge, can you be prepared for tomorrow? So therefore, I did not have legal counsel. I was not able to instruct one, and I didn't have adequate time to prepare my defense. So all that occurred on 13th June. My application for further time was also dismissed. And right there and then I was asked, how do I plead? Obviously, I said I'm pleading not guilty. But it is important to understand that I did not participate in the trial on 13th June 2022. Now, questions are asked about why didn't I put an affidavit in, or why didn't I respond? I didn't put that affidavit or any other response because I was looking forward to putting forward my defense at the hearing. And for that, I needed a lawyer, a competent lawyer, and I needed adequate time to brief and instruct. So I was therefore denied my right to legal counsel, which is enshrined in the Fiji Constitution. I was most of all denied my right to a fair trial. And I did not participate. My only participation on that day during the hearing for committal was simply to enter a plea of not guilty. And then I was given the option to take the witness stand. And once again, I protested to the court and I said, look, I cannot take the stand to give evidence because I am not prepared. I am not ready. I was again asked to take the stand. I again refused. I was asked for a third time to take the stand, and I responded by saying, I will not take the stand to self-incriminate myself. I know how it works. And therefore, the trial concluded. So you need to understand, I did not participate in the trial, the committal trial on 13th June. It was a one-way ticket, one-way traffic. Literally, it was a one-way street. And so I was denied my right to a fair trial. I was denied my right to legal counsel. I was denied my opportunity to be silent even when faced with such proceedings, and I was not able to participate. So anything after that was just all a one-way street, and it was simply no evidence from me whether to look at or to compare or to able to say that this is what Aman is saying in this action. And I find it disturbing. I find it something that should not have occurred, because you can't just rush a process and find the guilt or otherwise against a person if you have not given that person the opportunity to participate. So simply for me, it was almost to the point one, I was being rushed through the process, uh, but I was not given the opportunity. And for that, I filed a constitutional redress in the High Court on the grounds that my right to a fair trial had been violated, my right to legal counsel had been violated, and my right to silence had been violated. I placed the paper before the High Court.
And what happened to that constitutional redress application?
I filed it on the 19th of July. It was issued. It was issued about the 9th of August. It's almost 20 days later. I understood that it was before another judge, and it was called on the I think on the 18th of August. Once again, because I've had so much difficulty even finding a decent, competent lawyer to represent me. I had already departed Fiji, so my constitutional redress matter, which was called on the 18th of August 2022, last week, was dismissed, unfortunately. But that was my challenging the hearing of 13th June 22, whereby I was denied my fundamental basic constitutional rights, including right to a fair trial, right to a legal counsel, and right to silence. So that is something I need to obviously look at, and how I could probably bring it back before the courts in the future.
All right. Aman, have a drink of water, have a little break. Here's a special message to our admin team. Admin, I hope you're watching. If there is any nasty comments about the judiciary or a judge, can you please immediately remove that from the screen? I saw one a little while ago. Admin, please be reminded, we don't need any nasty comments about any judge or judges or the judiciary. We're just presenting a interview here, and we'll continue doing that. You're watching Sashi Singh's Talking Point, and our chief guest today is Mr. Aman Ravindra-Singh, Fiji's human rights lawyer, an advocate for freedom of speech and freedom of expression, and a gentleman who's made national headlines when the Fiji Times reported him as gone with the wind. A little later on, we'll be taking some questions from viewers. If you have questions that you'd like to put to Aman Ravindra-Singh, you may put them in the next 15-20 minutes on the comment section, and I will pick some questions to ask of Aman. But we're still breaking going into compartments to unwrap this whole case. Aman, what did you do after the hearing date of the 13th of June? What was your next step?
As I had mentioned earlier, I was not able to participate in the proceedings, and it was a one-way ticket, basically, till the next event. So after the hearing on 13th June, the date for ruling was set, and on the 28th of July, ruling was delivered. And on the 28th of July, because I now anticipated what was going to happen, and obviously because there was zero evidence from my part or from my side in the proceedings, I knew what was going to happen. So I looked at my options, and I prepared a permanent stay application for with all the evidence of Qayyum and his lawyers misleading the court, and simply put, lying to court, and which all added, in my view, to perverting the course of justice, which again I hold as judicial treason by any lawyer or any person who commits that particular offense, perverts the course of justice or attempts to pervert the course of justice. So I went to court on 28th July, and that was the date of the ruling by the judge, and I was convicted on the proceedings. I was convicted for contempt of court. I was convicted that morning at about 10:30 on the 28th of July. Within 2 or 3 hours, I had lodged my application for a permanent stay in the High Court in Suva.
All right, we'll come to that now. Looking at the committal judgment itself, at paragraph 28 of the committal proceedings judgment, the judgment read, and I quote, "After Judge Senivaratne delivered the judgment and after the commencement of the committal proceedings, the respondent, that's you, continued to post the following posts on his Facebook and used hashtags Violent Vorenge and hashtag Corrupt Qayyum when referring to the applicants, despite having a judgment in place which clearly condemned and adjudged that the words Violent Vorenge and Corrupt Qayyum are defamatory. You made 31 subsequent posts on your Facebook page where you used the hashtag Violent Vorenge and Corrupt Qayyum. Aman, a normal person, would perhaps have restrained himself or herself from continuing to use these words, especially after the court orders of 24th July 2020. Why did you persist in using these hashtags?
Well, again, as I've mentioned, it's a clear example of Qayyum and his lawyers misleading the court and perverting the course of justice. And I will qualify that again and bring forward the judgment of 24th July 2020, which was sealed on the 30th of July 2020. And it only contains 5 orders. And those orders have been read in the last hour or so. I need not continue reading them. But when these orders were read, you would find one particular point, that in none of these orders, 1, 2, and 3, the significant orders, does it say that I am not to say a particular word or words, or that I am not to call someone a particular name or names, or that I am not to put on my Facebook page a hashtag with a name or names. Remember, this is not the law of the jungle that I'm following. I am following the orders of the High Court of Fiji, not the law of the jungle. And that's what I do. And that's what I did. And a closer look at the orders of 24th July states, pay the 1,020, apologize on Facebook and 2 daily prints, and take out the subject article immediately. Where does it say, do not use the word corrupt Qayyum or violent Vorenge? Where does it say, do not print on your Facebook the words corrupt Qayyum and violent Vorenge? Where does it state that I cannot do these? Nowhere. And as I said, it appears that Qayyum and his lawyers are able to read things which are written in invisible ink, which unfortunately I can't. So this was another clear miscarriage of justice, and this was another clear move by these people to politically persecute me and to import words into this judgment, which did not form the High Court orders. As I've said, you must follow the High Court orders.
All right. You've just said that in those 5 orders that were handed down on the 24th of July 2020, there was nothing which banned you, there was nothing that gagged you, there was nothing, there was no clause that refrained you from using any word or words, including the words violent varenge, corrupt kayum, etc. And if one has to accept your reasoning that there were no gag order or restraint order, now are there any precedents in case law where the court's judgment actually spells out what a defendant cannot do? In other words, that the actual orders spells out the restraint clause. Are you aware of any such precedents?
Yes, I am aware. First of all, if I apply common sense, if it was written in black and white in the order and the sealed order of 24th and 30th, if it was written, then I would have followed, right? I think that is what I was supposed to do because it is the order of the court. And I would have followed the orders of the court. I would not have had any reason to do otherwise. As I said, it's not my problem that Kayum and his lawyers can't read simple and plain English. And any lawyer worth their salt, well, he's got a team of lawyers. I can't understand how they have managed to stretch court orders and import words and import terminologies, and in fact, even write a judgment or an order or write orders which only they seem to know about and which I don't have in front of me. This is what has happened in my case. Now, perfect examples, and there have been a few cases in Fiji. One is the water case, crystal clear mineral water and natural waters of Viti. In this case, there was an order by the High Court which which basically said that the defendants could not use the word Fiji, F-I-J-I. And there was a restraint. And the particular order basically said you could not use the word. And the defendant went and used the word Fiji while there was a restraint. The defendant was refrained from using the word Fiji. Now, that is a clear order. And when the defendant did not comply and used the word again, that was a clear breach. Was there any order in the 5 orders from 24th July 2020 restraining me from using the words violent barangay or corrupt kayum? No. There's another case. That would be the Rewa Dairy case against Eagle Ridge. And that's again from the High Court, where the word life, L-I-F-E, was not to be used by the defendant. And the court had ordered that the word not be used. And when the defendant used that particular word life again, the defendant was found to be in clear breach of a court order. You can say that was a gagging order or an order which basically refrained the defendant from using the word life. And again, the order was specific. It said, do not use this word. The moment the defendant used the word again in committal proceedings, to what I faced similarly, the court found that there was a breach and there was a contempt, and therefore a finding was made. Again, I asked the question, was there a restraint order against me from using any such word or words? No, there was no such order. But what Kayum and his lawyers once again did is they imported and stretched the orders further, and they came to court with, if you could look at the thickness of this document,
Yes.
that's quite, yes. So Kayum came to court with an affidavit with 31 of my Facebook posts published, extracted from my Facebook page, and which had the words violent Varangi and corrupt Kayum, and then complained to court to say, look, not only am I defiant, but I was also once again showing total disregard and no due respect for the court, and I continued to show total defiance. And those 31 Facebook posts were then added to the complaint against me, and it was used as examples of my lack of compliance and showing of defiance. As I've said, this was all imported into the courtroom and advocated by the plaintiff's lawyers to the court to say, look, here are clear-cut examples of Aman's defiance, and he has continued to show total disrespect to the court. Now, all of this was pointed out in my application, which I had made to the court on the 28th of July, 2022, in my last attempt to get the matter against me dismissed. And that was the application for permanent stay, in which I very clearly asked the court to look at the orders, and I very clearly pointed out that there was no gagging order against me. There was no restraining order against me. There was no order which specifically said I could not write a word or words. I could not write a hashtag with a word or words. I could not say, or I must not say, and I shall not say the words corrupt Kayum and violent Varangi. There was no such court order.
All right. You've said some things that was actually repeated in the judgment. The committal hearing judgment at paragraph 44, for instance, stated in part, and I quote, the respondent's willful, perverse, intentional, and deliberate disregard to the obligations imposed on him by the court or owed to the court by the judgment order dated 24th July 2020 is a far cry from a piece of breathtaking insouciance. For the benefit of my listeners, insouciance means casual lack of concern or indifference. Now, we've just discussed this, and I've asked you this, but when you hear that particular paragraph of the judgment, let me ask you, were you being willfully disobedient, and did you have total disregard for the court orders?
I was never willfully disobedient. I was never, ever, at any point, showing any disregard to the court orders. And as I have mentioned, I have only had respect for the court, and I have been in the courts for many, many years as a barrister and a solicitor. So that, again, for me, is a description which I cannot even identify with. That's almost like saying that's speaking against someone else. And I know a few people who are exactly that, and that description would fit them. I pull again an example of where the plaintiff Kayum evaded court service of papers. I remember in 2018 when there was a high court action, and all the government and the ministers hid in level 9 of Super Bowl House. All of a sudden having training past the midnight and all the way till the morning, and they even slept in Superbo House, hiding from a bailiff to be served court documents. That's a clear defiance of court procedures and court orders. That's the way people are able to do things and yet not be pulled up. But on this occasion, I am described as someone who I am not. And as I mentioned, those are what the plaintiff's lawyers had put forward in court. And it almost came down to the point that regardless of what I did, the plaintiff and his lawyers were just not going to accept anything. And each day I was in court, and every time I heard words from the plaintiff's lawyers, it was all designed to end me and destroy me at a particular point. And I could read the writing on the wall, and I continued to be shocked at what was happening.
I find it amazing that the orders that the committal judgment kept referring to were the orders of 24th July, which we have today time and time again. We've referred to those 5 orders, particularly those 3 orders. And yet, the judgment reads that, at paragraph 50, for instance, that there was a flouting of the authority of the court and willful affront to its power, and that you showed hostility to the court to indicate a contempt of court. What do you say to that?
As I've mentioned before, that's not me. I must be speaking about someone else. Because what hostility? Where is the evidence of hostility? What have I said or done in court? All I've done time and time again was to try my very best to defend myself in person. Firstly, because lawyers were so scared to even take up my matter. And secondly, I was just being dragged through the court process by the plaintiff and his lawyers, who continued to lie and mislead the court. And as I've mentioned, perverted the course of justice. That's what I was facing. I showed no hostility towards the court at any time. That's not me.
All right. I note from reading the judgment that you did, in fact, take the witness stand in the sentencing inquiry stage or the mitigation stage to give evidence, and that you said that you had a legitimate constitutional right to continue referring to the applicants as violent Vorenge and corrupt Kayum, as there was no injunction order or gag order restraining you from referring to the applicants as such. Now, in his judgment, the presiding judge in the committal hearing said quite interestingly at paragraph 53, and I quote, "The respondent's conduct should be characterized as attempting to find a weakness or loophole in the judgment orders and seeking to exploit that." I find that interesting, as it seems to suggest that the original orders did not have any restraint or gag clause, and that may be perceived to be the loophole that you exploited, so to say. What would you say to that? How would you respond to that?
Once again, as I've mentioned, I was not looking at exploiting any loopholes or trying to slip through the cracks at any point. But I again find it very disturbing that I was being made to climb Mount Everest, trying to continue to show my innocence or to show that I was not being in defiance of court orders. And those words that you have quoted, again, I simply state that the judge got the law wrong, that the judge got the facts wrong. And I am not able to say much more apart from the fact that the law needed to be applied in my case. I, just like any other defendant, needed to be given a fair trial. That my constitutional rights needed to be accorded to me. That I was sure about one fact, and that was the 5 court orders 5 court orders of 24th July 2020 and the sealed order of 30th July 2020 at no point restrained me from ever stating the words corrupt Kayum or violent Varenge. And I took the oath. On the 9th of August. And that was another strange day because that was the date for the ruling of my permanent stay. So I had placed all this overwhelming evidence before the court, and I had stated before the court, and this has been reported also in the Fiji media, and I very openly stated in court that Kayum and his lawyers had lied, had misled the court, and had done that on multiple occasions in my committal proceedings. And I laid all the evidence before the court. Now, the only decision the court should have made, right, was to simply say, okay, this committal proceedings against you is dismissed because there are multiple breaches of procedure, there are multiple miscarriages of justice, and on the documents, not who says what, not he says, she says, which the lawyers were very good at, slipping in evidence even without proper basis, but simply applying the law and making one finding. And that finding would have been to dismiss the action against me. But the permanent stay application went the other way. Despite the overwhelming evidence that I placed before the court, there was still a finding that I was in complete defiance, that I was still not showing any respect and everything else. So any person reading that ruling, the sentence and conviction would see that the tide was only flowing one way. And that was basically what was going on with the rulings coming out of court.
All right. You did mention the permanent stay application that you'd filed all the evidence. When and how was that determined? What was the final outcome?
Again, I could not come to court on a particular day. I produced a sick sheet and I had to be dragged out of my bed literally for the hearing of the permanent stay. I came to court in a very sick state. I could barely speak. I had a very severe bout of the flu. I informed the court that I had only come to court from Lautoka because there was a threat made that if I did not appear in court, the matter would proceed. And that's all matter of public record because I've said it in open court. So the permanent stay hearing was done, I think, a week earlier, on the 3rd probably or 2nd of August, in my sickly state. But all the evidence was there before the court, properly put in document form. My compliance of having had taken out the subject article on 24th July 2020, my first apology to the court on 16th August 2020, and all this was before the court. However, on the 9th of August 2022, 2 weeks ago, the ruling again dismissed my application, and there was not even half a finding made in my favor, or a quarter of a finding, or 1/5 of a finding. The court was not. The court did not accept my documents for the permanent stay, and it stated, which again was not the correct finding, that if I had any issues, to take it up to the Court of Appeal. But then that would have meant that I would continue being dragged through the system. And after conviction, there was only one thing left, that was sentencing. So when I took the oath on the 9th of August, right after the ruling was delivered for the permanent stay, judge asked me had asked me to come prepared for the mitigation. But I informed the judge that now that a ruling was made for my permanent stay and it was dismissed, I needed time to prepare and then come back to court because the dynamics changed. Anyone involved with trials would tell you that everything depends on the outcome of one decision from the court, and then after that another. So I managed to have engaged a lawyer for my mitigation, and I informed the court on the 9th of August that I needed either the Thursday, which was the 11th, or the following Monday, 15th. That was the lawyer's availability to bring this lawyer in for my mitigation. I made that application, but the judge refused. So I was left with no alternative but to go ahead and mitigate. So I wasn't prepared, but I only had one thing left, and that was to take the stand under oath and to say my part. And therefore, that's what I did. I took the stand and I informed the court about everything that had happened and all the evidence that I'd put forward, and that as per the law, I had a right to express myself and I had a right to say what I wanted as long as it was not criminal, as long as I was not breaking the law, as long as I was not inciting people or asking people to commit a crime, or as long as I was not in defiance or disobeying a court order. I
All
said
right.
that
Well,
to
okay. Have a break, have a drink of water. We'll come back to you shortly. We'll come back in a moment to discuss the sentence that was handed down and why Aman Ravindra-Singh left Fiji. You are watching Sashi Singh's Talking Point, SSTP, live on Facebook and on YouTube. Our chief guest today is Mr. Aman Ravindra-Singh, Fiji human rights lawyer and an advocate for freedom of speech and freedom of expression. Please note, please note that if you've joined us today for the first time, you can watch all the previous episodes from episode 1 to episode 32 either on Facebook and on YouTube. So go to the SSTP page and you can see all the previous programs. And a very big welcome to our brand new viewers who are joining us for the very first time today. Please ensure that you like and follow the SSTP page so you can get all future notifications for the program. Aman, back to you. On Tuesday, 16th August 2022, Judge Jude Nanayakara sentenced you to 10 months immediate imprisonment for contempt of court. Firstly, what was your reaction to the sentence passed down?
I was not surprised, not at all. And in fact, I knew what was going to happen. There had been warnings, and the way the court proceedings had been unfolding, and the way Kayum and his lawyers had put evidence before the court that misled the court, that lied to the court, that perverted the course of justice. As I've said, black and white, it's there. It's not me saying it or dreaming about it. I was not surprised. In fact, very unethical conduct by one of Kayum's lawyers, having stood up in court, continuing to advocate the lies, and even asked for a 2-year jail sentence for me. But the writings were on the wall, and I had a rude awakening, a light bulb moment on the 9th of August when I received the ruling for my permanent stay. And then right there and then I was told to start mitigating. Look, I've even done murder trials. Even after conviction, a murderer is given more time to mitigate. We understand how the system works, but I was told right there and then start mitigating. And despite even saying I had a lawyer on board now to mitigate on my behalf and to give me at least a day or two, or the 11th or the 15th, I was still told to mitigate. So again, this was a rush. And that light bulb moment was on the 9th when my permanent stay application was dismissed. I was told to mitigate and to go for it. And that's when I seriously had that switch turn on in my mind, and that light bulb came on. And I walked out of court and met two very close mates of mine, and I said to them, "This is it. This is it. There's no going back. There is absolutely no going back." And everything that has been happening for the last few years, everything I've been told, everything that's come by way of threats, intimidation, it's all coming true. I could just see it. And that is what happened. The penny dropped on the 9th of August 2022, 2 weeks ago. And I knew my fate was sealed. And that was definite imprisonment. So when the ruling came out on the 16th, I didn't even bat an eyelid.
All right, still talking about the sentence that was passed. Did it surprise you at all that it was not a suspended sentence, or that it was not a further fine to hurt you financially, or that there was not even a parole period as part of the sentence?
No, not surprising, because I knew my fate was sealed and it was going to be imprisonment. I was warned that I would be imprisoned. I was warned. And this was the moment when the ruling came out, the sentencing came out. As I had mentioned, I was not surprised at all. But yes, I think in speaking more generally, after all that I had done and all the evidence before the court and the compliance and everything, first of all, my straightforward conclusion would be my matter should have been dismissed, and the court should have found in my favor that I was not in defiance of court orders, and if anything, the court orders had been complied with, or otherwise the statement had been complied with. And as I said, the statement is where the complaint is written or where the allegation of non-compliance is made. And when you look at the statement for the committal proceedings, it's clear. It says, I failed to render an apology. And in simple English, an apology means one apology and failure to pay $120,000. So throw everything out. Nothing else matters. Apply the law. And as per the contempt of court proceedings brought by Kayum and his lawyers, they only said to the court that I had failed on two fronts, two orders. Did not pay 120, and I did not render an apology, one. Now, their own statement said that. And all the court needed to do was look at the statement, look at what the evidence was before the court, and to say, well, maybe there's 5 orders or 10 orders or 50 orders, but the statement says 2 failures. We need to apply the law and look at the statement for what it is. There is only 2 orders that have not been complied with according to the statement. So therefore, let's look and go from there. I had rendered an apology on the 16th of August 2020, and with regards to the 120, there's something called willful negligence in law, and in contempt proceedings. Let's just say if the order is for me to climb Mount Everest, I need to go and put a flag up there, and I can't because it's too difficult. So have I willfully neglected to reach that summit? No, because I couldn't. I didn't have the oxygen, I didn't have the money, I didn't have the plane fare. Same thing applies in this matter. And the court was to look at if I had willfully neglected to perform my part, which was to pay 120. And what the court needed to do was ask me if I had the money. Now, for example, if I had $1,000,000 sitting in my bank account, and yet it was a well-known fact, and the court asked me to bring my bank statement and present it, and the court said, wow, you have $1,000,000, and yet you have not paid. Why have you not paid? And if I have no proper excuse, then the court will say you had the money, you failed to pay, therefore you are in contempt. But at the same time, for someone like me who did not have the $120,000, that was not willful neglect. That was simply not having the money. So when you look at the statement and the two complaints, failure to pay, that should have been dismissed because I didn't have the money, or right in the end, I managed to pay it, so that should have been a dismissal, and render an apology. One, I'd done that on 16th August 2020. So the matter should have been dismissed.
All right. We've been going for something close to like 2.5 hours. We'll go for just a short while more. How do you then seek redress for what you term to be a miscarriage of justice?
Well, first of all, I need to identify a competent legal counsel. And once I have been able to do that, then I will be able or be in a position to discuss my matter and look at my options. I'm not going to rush this. I've had too many disappointments along the way, and I'm going to do this properly. But I will be surely taking this on, and I'm not just going to let it sit.
There is now a bench warrant in place for your immediate arrest. How will you come to terms with that?
The bench warrant is court procedure. As mentioned earlier, if someone doesn't show up, there is a bench warrant issued. That means that it has been issued against me, and it awaits me. It is what it is, and I will deal with it at the appropriate time. But for now, I'm not bothered about the bench warrant, because what was more important was for me to get to safety and be able to breathe the air of freedom, as opposed to being in Kayum's prison for having not committed a crime, for having done nothing wrong. I am no criminal, and I have not broken the law. It's unfortunate how things have transpired.
Now, before I ask you for the reasons as to why you left the country, let me ask you about the Attorney General's comments. He held a press conference last week, which started about you. And in that press conference, he said that your conduct, and I quote, demonstrates a complete lack of respect for the rule of law, end of quote. How do you respond to that?
The Attorney General pointing a finger at me and saying that I have shown a complete disrespect for the rule of law? Seriously? Kayum is in no position to preach to me or to the nation about breaches to the rule of law. This is a man who has blatantly and completely shown disrespect for the rule of law, and again, it's documented. This is the same person who became the legal advisor for a unlawful military regime which took power on the 5th of December 2006. There is a Court of Appeal ruling dated the 9th of April 2009, which states that Bainimarama and Kayum and all the other clowns had committed an unlawful act, and that the coup of 2006, 5th December, was unlawful, and that Fiji was to return to parliamentary democracy. And Kayum, on the 9th of April 2009, was the Attorney General of Fiji. Well, the illegal one. What happened on the 10th? Kayum, the illegal Attorney General, then participated in the abrogation of the 1997 Fijian Constitution. Now compare what he said to me, which is without any foundation and baseless, and look at his acts, where he's committed all these crimes and participated upon his advice to rip up, tear up, and burn the 97 Constitution. So he is in no position to preach to me about showing any sort of disrespect to the rule of law. I have had a history of making a stand for the rule of law. I have been fighting for the rule of law, not from yesterday, but for many, many years. And I have basically stood by the rule of law. There is no comparison, and there never will be any comparison between Kayum's complete and utter lack of any respect for the rule of law and for me. My action speaks for itself. I need not even explain any further.
All right. In the same press conference, the Attorney General also said that you had shown, and I quote, deliberate malice, disrespect, and some will say cowardly behavior, end of quote. How do you respond to that? What is your response?
Again, this person just believes his own lies. I think, first of all, it's a distinction to be called a coward on national television by the very person who has torn up and burned the Constitution. But let me put it this way. I think he's delusional because calling me a coward is laughable. I have stood alone against the Fiji military, against the Fiji police, against the Fiji dictatorship for many years, and I've done it alone. And what has this person done? Hid behind the gun. That's Kayum for you. So who's the coward here? Who's the coward? I walk the streets alone. I've never had a bodyguard. Kayum has 30 bodyguards at any one time. Has 10 vehicles with bodyguards armed to the teeth with guns. I've never had protection. I've never had anyone guarding me with guns. So who is the coward here? Calling me a coward again, it just shows his delusional personality and his very stoic mindset. Very, very small. And it's a shame because he's gone and said that on national TV, but no one's asked him about his own conduct, past, present, and future. So there is no way that he calls me a coward makes any sense. And as I said, my work speaks for itself, and I have stood for the rule of law. I've championed democracy and human rights, and I've been doing that for quite a while. I'm known for that, and I think the biggest coward in all of this is Kayum himself, and I'd brand him a national coward and a national disgrace. That's who he is. Everybody knows he's scared, and he can't do anything alone, and he can't walk the streets of Fiji alone, only to be hiding behind the guns. So seriously, take out the guns and try to walk the streets alone. Take out the bodyguards, take out the vehicles and all the guns, and come forward. So
all right, now,
it.
sorry, go on.
But that's it.
All right.
And the fact of the matter is that calling me a coward again, as I said, is coming from someone who's delusional.
Aman, you mentioned, he said that on national television in a press conference, which was beamed to the worldwide audience. I'm just trying to draw a distinction here. Was this not a private case? It wasn't like the government of Fiji taking you to court. The two plaintiffs could have been or were the Prime Minister and the Attorney General, but it was a private defamation matter, was it not?
Oh, yes, you're absolutely correct about that. Let's put it this way: the action brought against me was by Kayum and by Nimarama in a private capacity, and that meant that they hired a private law firm.
Mhm.
It was nothing to do in their official capacity as the office holders. What I
The,
again, sorry,
the reason I raised that is that if it was in a private capacity, then why would there be a press conference on the government page, on the Fiji government page, to hold a press conference nationally? What's your
it,
response?
it's simple. It's a crime which is called abuse of office.
All right. Aman, something that's just come in this morning. And before I ask you as to why you left Fiji, I'd like you to sit back and listen to what I'm going to perhaps summarize. I would like to state that I have obtained a very high level analysis of Aman's case from an eminent jurist. At this stage of the proceedings, I cannot disclose the name of this eminent jurist. That is not important. What is important is the analysis provided. A number of very relevant points have been made to me in writing, and I will share some of these with you now. Point one: a year after the proceedings began in October 2021, the second plaintiff, Ayar Sayed Kayum, files another affidavit in court. In this affidavit, Kayum has a go and files a complaint about a number of things that Aman allegedly said about him, and that too after the contempt proceedings were issued. In this affidavit, the second plaintiff, Kayum, states that Aman Ravindra-Singh is defying the orders of the court and that his and the first plaintiff, Bani Marama's reputations were being harmed, etc. Point two. Point two is that it is uncertain, unclear, and belies belief as to why the additional affidavit was allowed in the first place. The fact of the matter in the legal process is that one just cannot go ahead and file an affidavit with a whole lot of new allegations. Why? Because it has nothing whatsoever to do with the original contempt alleged against the defendant, who in this case was Aman. Point three is that the second plaintiff, Kayum, did not make an application to the court to make and file an amendment to his original pleadings. In other words, the second plaintiff, Kayum, did not seek leave of the court to make amendments to his original document. The example is that it is like Kayum saying that I initially sued you, Aman, for damaging my Prado, but since then, you've gone and done other things like you've destroyed my garden, you've destroyed my office, you've burnt my house, you've thrown bricks at my car. So let me just file another document in court and we'll deal all of these matters together. Point four is that if there are new allegations to be made against the defendant Aman, then these must be properly set out in the proper application. And there are strict procedural rules that have to be followed. These would be prescribed in the rules of the court. Procedural fairness has to be accorded to all parties in any court proceedings, and these rules cannot be bent just because one of the plaintiffs is the holder of a high position in government. Point five in the analysis is Basic Law 101. That is, if Aman continues on his verbal attacks on Bai and Kai and says more nasty stuff about them, even if some of his utterances are defamatory, This does not breach any court orders. There are no court orders to say you must not say nasty or bad things about Qayyum and Bainimarama. If Aman persists to say nasty things about these two men, then in law, these two men have their remedies. File another lawsuit and sue Aman Ravindra-Singh again. You just cannot say, hey, Aman, you are in contempt of court. Point 6 is that this matter of Aman was originally just a civil defamation case. There is a distinction between that and a criminal contempt case. When one has attacked the integrity of the court, where one has brought disrepute to the courts, it just boggles the mind as to how the presiding judge got it into his thinking process that all of Aman's new Facebook posts, which in the first place should never have been presented to the court, had somehow brought disrepute to the integrity of the court. The judge said at paragraph 20, and this is what he said, and I quote, "This is what I have found on the unchallenged affidavit evidence. Any ordinary reader who read the Facebook posts of the respondent would deduce from that they were intended to convey that the applicants are corrupt. As Justice Seniviratne held, this is libelous. The allegations made by the respondent against the applicants in the Facebook posts are calculated to cause damage to the applicant's personal integrity, professional reputation, honor, courage, loyalty, and the core attribute of their personality, and is calculated to bring the court and the judge into contempt or to lower its authority, and there is a real risk of undermining public confidence in the administration of justice." End of quote. Point 7, which is summary. Originally, this was a contempt case because it was stated that Aman had not paid the money and had not rendered an apology. Without explanation, it just seems that Qayyum was allowed to file in court more irrelevant facts pertinent to the case. If Aman had stated more nasty things about him, Aman is not in contempt of court. If Aman has said nastier things and Qayyum is aggrieved by that, then it is simple. Qayyum can sue Aman Ravindra-Singh again and again and get damages and other orders issued by the court. But in this case, Aman has not disobeyed any court orders. There was no court order that said in the simplest of terms, Aman, stop saying nasty things about Mbai and Kai. Full stop. And the last point, point 8, is an observation that goes to show that by the end of the judgment, the judge was not concerned about the money aspect of the case, but made a decision on a new set of evidence presented by Qayyum that had nothing to do with the original court case, and that Aman is guilty of contempt of court. The startling thing is that the contempt for which Aman is guilty has nothing whatsoever to do with saying nasty things to Mbai and Kai, which is civil contempt. But he's been judged for making the court look bad, which is criminal contempt. This is something that we've got from an eminent jurist. For now, that is sufficient to show how the whole process has been dealt with, some would say, rather incompetently. Aman, briefly, what are your thoughts on this legal analysis from the jurist that I've just read?
As I had stated earlier, and what I had said in my earlier responses, that there were multiple breaches in my matter. There were multiple miscarriages of justice, not just one or two, but multiple. And that matter should have been dismissed a long time ago. I totally
All right.
agree with the points made. I totally agree, and I'm glad that someone has able to decipher the entire miscarriages of justice and put it so succinctly. I'm in full agreement.
All right, wonderful. Um, all right, we've been going for quite some time. Now, let us address the $1,000,000 question. People have been waiting for this answer, I guess. Aman Ravindra-Singh, why did you leave Fiji before the sentencing date?
I left Fiji to escape political persecution and to escape my death. And I need to explain to you what had been occurring and where things uh, would have ended. I went through a lot, and if I take my time and try to explain each and every event that has occurred, I will keep the listeners glued on for much longer. I'm aware of the time constraints. Look, in my human rights work, in my defense of human rights, advocating for human rights, standing up for anyone and everyone for whenever there's been a breach of human rights in my country, it's been costly. And I have never become the subject of matters. I have always been in the background fighting a good fight. There had been things happening, and about 3 years ago, I was threatened. But I've received threats on average of every third, fourth month, sometimes on a weekly basis, and this has been going on for the last 10 odd years. About 3 years ago, I was threatened that I would be killed. I would be imprisoned and then killed. And those close to me would attest to this, because I had been sharing this with people for a while. So it just didn't happen yesterday. And then this committal proceedings happened, and everything else that took place, the miscarriages of justice, the flaws in the procedure, and everything kept going on. Beginning of this month, my 3 guard dogs were poisoned at my home within the course of 1 week. And at the beginning, I was very shocked about my dogs, but I had lost 4 guard dogs with a similar poisoning event in 2017, and I drew a nexus to that. But after the first week, I received a phone call, and it said something to the tune of your dogs are gone and you will follow, and it's only a matter of time. You will be going to jail and you will never return. And as I said, I carry a lot with me, and the first time I was informed about being jailed and by the regime and never leaving alive was about 3 years ago. That the description was I will live in a body bag. And it's around that time too that I was exposing prison deaths. I'd given an interview about human rights violations in 2019 in June. I presented a paper with regards to violations of human rights in Fiji prisons. So when I got this call in the beginning of the second week of August, which is like 2.5 weeks ago, as I said, and then I went to court on the 9th, and I saw that despite all the evidence I had placed before the court, my the matter was not dismissed, but I was now heading towards sentencing. And as I said, I had that light bulb moment, the penny dropped, and the call kept on repeating in my mind, and I was able to put all the pieces together. And I fought a good fight. I never at once just reversed and left the country. I had been advised for the last 12 odd months to leave Fiji. My close associates and certain people had been advising me to leave Fiji. It's no secret that members of special branch in Fiji are also able to link with people like us now and again, and because they're not happy with what goes on or the dirty games being played. So I had been receiving reports, and I've been facing a lot of harassment, a lot of intimidation, being followed. But this has happened for the last 10 odd years. And as I said, I'll speak about it hopefully on another day. But for now, that was it. When I came out of court on the 9th, my mitigation was rushed. All I could see was prison, the gates of prison. Every flaw I identified, every miscarriage of justice, it was all pointing to one thing and one thing alone. That was my imprisonment, the poisoning of my dogs at the beginning of the month, the threatening phone call. It all made sense. And at that point, I had to make a decision, which is not easy, but I had to. And that was it. I had
All
to.
right. Okay, let me just stop you there for a moment. There's a lot more to be discussed. I just want to reiterate something. I know you've said it. When were your dogs poisoned in this last incident?
The first week of August.
This is this month, first week
This
of
month,
August.
Yes, yes.
When did you get that phone call that you've just mentioned?
About 3 days before about 2 days before the 9th, probably around the 7th.
And what was said on the phone call to you?
Simply to the tune of, your dogs have gone and you will follow, you will end up just like your dogs, dead, and you are not going to leave prison alive.
Once you heard those words, what went through your mind?
My mind kicked into survival mode.
Mm-hmm.
That
Okay.
was it.
All right. Aman, we're just getting on to 3 hours. It's not fair for me to subject you to a lot more questioning. Would you be willing to make yourself available next Sunday? There's a lot more to be discussed. I'd like to dissect all the threats, the intimidation, um, violence, perhaps if you've ever endured violence. And then I'd like to also discuss with you matters in relation to human rights in Fiji, matters of politics in Fiji. Would you be kind enough to make yourself available for next Sunday so we can continue? Are you available?
Yes, I am available. Right now, I don't have a job. I don't have an office to go to. I have some time on my hands.
All right. Well, I would like to say thank you very, very much. One question, and I've noticed that a few viewers have asked that question. Um, how's your family back home?
It's something I'm not willing to really speak about publicly, but it's not easy. Times are difficult, and something which I would rather not speak about. But they continue, obviously, to be under the spotlight, and the intimidation continues, the harassment continues.
All right. We'll dissect that next week. During the course of the program, I just jotted down there was a post by those closest to you, dearest to you, and Little Champ was watching his Lion King. So that's going to bring you a lot of comfort as well. And I don't have to mention where that is from. Aman, as I said, there's a lot more to be discussed in next week's program. And for now, I really, really thank you. But before I let you go, since the day people in the Fijian diaspora heard that you had left Fiji, the court of public opinion has overwhelmingly offered their support to you. Firstly, what do you say about the groundswell of support people have given you?
I'm very, very thankful for all the overwhelming support that I've received, and I hope to meet many of you in the future. I may not be able to meet everyone, but Um, I'm totally appreciative of everything. When my mind kicked into survival mode, obviously these are not things you think about. It wasn't like I even had that luxury to think what would one think. But after my departure, um, there was a lot of support expressed by friends, strangers who no longer are strangers to me, but friends, not just from Fiji, but abroad, from the Fijian diaspora. And there's just no way that I can thank each and every one of you personally, but I take this opportunity to thank each and every one of you by these means. And I'm just overwhelmed by your strength, your prayers, your guidance, and just from the bottom of my heart, say a big minakapakalebu dhanyabad, and thank you so much. And be rest assured that my work will continue, and my fight for human rights for our people will continue. There is
Oh,
no stopping, and there will be no stopping until we get it right.
all right. And I just wanted to add another point with so many messages of goodwill and support for you on so many different platforms. So much so that I heard a couple of days ago that at the Los Angeles Sevens this weekend, there are people wearing t shirts with your photo in the front with the hashtag, I'm still standing. How does that make you feel?
Again, I'm so appreciative and so thankful for the support and for the group out there in Los Angeles. Thank you so much. Thank you so much for taking that extraordinary step to publicly go out and show not only support for me, but for the respect of human rights and in support of human rights for our people back home. That means a great deal to me and to the people back home. Thank you so much.
Aman, thank you very much for taking part in Sashi Singh's Talking Point this afternoon, episode 33. We look forward to your participation next Sunday in episode 34, where we have so many more subjects to unpack, discuss, and deliver to our viewers. Have a blessed Sunday. Stay in the background if you can. Stay there. I have a little surprise for you before I finish the program. It's been an absolute pleasure having you as chief guest today. Aman, once again, thank you very much. And have a good day.
Thank you very much.
All right. Well, that is what we have for you for episode 33. Don't forget, you'll have to tune in episode 34 because there's some big, big bombshell moments coming in episode 34. I can assure you of that. A big thank you to my regular contributor, Nikhil Singh, for his input in the program, to my SSTP team. A very big thank you as well. And I would like to thank you, all our viewers, for watching this program today. And there's no reveal. It's already been revealed as to who our chief guest is next week. It's going to be Aman, and to that wonderful gentleman who was going to be our chief guest next week. I will not mention your name. I will contact you tomorrow. I render you my apologies, and we will have you in the following week as chief guest. So don't miss episode 34 next week in the program. Aman, this is a little surprise for you. Well. The man says hashtag I'm still standing. So until the next episode, I wish you all a very safe and happy week. In closing, I'll leave you with this quote from Mahatma Gandhi, who said, there is a higher court than the courts of justice, and that court is the court of conscience. It supersedes all other courts. I'll repeat that. There is a higher court than the courts of justice, and that court is the court of conscience. It supersedes all other courts. that quote from Mahatma Gandhi. Well, that's it for episode 33 of Sashi Singh's Talking Point. Till the next program, I am Sashi Singh, bidding you goodbye, namaste, and ni samode. Goodbye, world.